we're going to tell you a few things about the judges who will be dealing with this matter. Let me grab this sheet of paper I made some notes on it as I was preparing for the show. Okay, so we always like to remind you, and this is especially for students who want to learn, political science students, young people in secondary school, that whenever there's an election petition, remember, it is predicated on Article 64 of the 1992 Constitution. 64, you can't forget that. 64, the Constitution, I believe, has 297 articles. Article 64 is the challenge of the presidential election. The validity of an election of the president may be challenged only by a citizen of Ghana who may present a petition for the purpose to the Supreme Court within 21 days after the declaration of the result of the election, in respect of which the petition is presented. Now, this is to tell you about the Supreme Court when they are sitting. When the Supreme Court is sitting in a matter like that, and they began sitting today for the election petition that has been filed by President John Dramani Mahama. Article 128 is what really governs the sitting of the Supreme Court. What did I say? Article 128, the composition of the Supreme Court and qualifications of its justices. 1281 says the Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. There it is again. The Supreme Court shall consist of Chief Justice and not less than 9 other justices of the Supreme Court. And then 1282 says, the Supreme Court shall be duly constituted for its work by not less than 5 Supreme Court justices, except as otherwise provided in Article 133 of this Constitution. So that's very important. It says the Supreme Court shall be constituted by not less than 5. So the Supreme Court cannot be 3, it cannot be 4, it cannot be 1. It has to be in its original jurisdiction to sit at least 5 judges, This morning, the Chief Justice empaneled 7. And we're going to look at who the 7 are. Okay, now it says except in Article 133. So we will look at Article 133 and see where the exception is, where in which case the Supreme Court should be sitting more than 5. We'll show that to you in a minute. Okay, now this is the composition of the Supreme Court and the qualifications of justice. That's Article 128. So 1283 says, the Chief Justice shall preside at sittings of the Supreme Court, and in his absence, the most senior of the justices of the Supreme Court as constituted shall preside. So this simply means that the Chief Justice shall preside. If he's not available, the most senior judge of those sitting will preside. Okay, so let's now look at the exception where the Supreme Court can sit more than 5 justices. It is in Article 133 and is here. The Supreme Court may review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by the rules of court. The Supreme Court, when reviewing its decisions under this article, shall be constituted by not less than 7 of the justices of the Supreme Court. So I think you get it clear now. So it says that where the Supreme Court is sitting in its review jurisdiction, when they have already heard a matter and they are hearing the same matter again, the Supreme Court shall sit as 7 justices. So the philosophy is that in the original matter, they sit as 5. And then when there's a review on the matter, they add 2 more judges. That's the philosophy. So when they sit as 7 and there's a review, they usually would add 2. When they sit as 9 and there's a review, they will add 2. That will be 11. But now they are sitting as 7. Who are the 7 that are sitting? And is the Chief Justice sitting on this matter as well? And who are they? Okay. There it is. His Lordship, Justice Eni Yeboah. He's sitting as one of the judges. And I'd like to say a few things about each of the judges tonight. Now, I have my notes here. So Justice Eni Yeboah is noted for his fidelity to procedure. So, you know, the rules of court and the practices have certain procedures, especially the Anglo-American jurisdiction of law. That is to say, the law that we inherited from England, the common law. There's a lot of procedure. That is to say, when you are filing an election petition, you have to file it this way. When you are filing a divorce petition, you have to file it this way. When you are filing a writ of summons, you have to file it that way. Those procedures are in the book of procedure, generally known as civil procedure. Some lawyers have extensive fidelity to it. Some lawyers, you know, sort of allow it one way or the other. Justice Eni-Eboa is one of those judges when, during his practice as a barrister in the Eastern region, was very big on procedure. Throughout his time as a barrister, he rose to become the president of the Eastern Region Bar before he became a justice of the High Court. He has fidelity to procedure. So you have to know that about our learned Chief Justice. He has intense fidelity to procedure. He likes the procedure. He's a judge of procedure, a justice of procedure. Now, he also has a philosophy. And he's also a man who takes a decision about the law and is very clear about it. He's a man who hardly changes his decision about the law. Now, I'm going to show you a video. This video is about His Lordship Justice Eni-Eboa appearing before Parliament's Appointment Committee, okay? Now, there was a case that was held in Ghana, and it's about an interesting personality, my friend Dr. Zanetta Rawlings. By the way, congratulations to her for picking up the seat again. Now, Dr. Rawlings had filed to become a member of Parliament for the NDC, to challenge for the NDC's candidate for the Klotikole constituency. Her opponent, Adom-Otchere, had gone to the High Court and filed a writ against Dr. Zanetta Rawlings. Adom-Otchere's concern was that Dr. Rawlings was not a registered voter. As you know, one of the qualifications for a member of Parliament is that you ought to be a registered voter. So the High Court ruled that Dr. Rawlings was not a registered voter. Also, Dr. Rawlings and his lawyers filed an application to the Supreme Court. And in their application, they were arguing that the High Court has taken over jurisdiction that ought not to be for the High Court. That is to say, the High Court has entertained a matter that they shouldn't have entertained. Now, how do you know which court must entertain a matter? It's all in the Constitution, and some of it's in the rules of court. So, a matter for the interpretation of the Constitution is for the Supreme Court. Any matter for the interpretation of the Constitution is for the Supreme Court. The High Court has its own jurisdiction, etc., etc. So, lawyers for Dr. Rawlings were making an argument that the High Court has no power to go through the Constitution and make a determination whether Dr. Rawlings at a certain time was a registered voter or not, and whether that status disqualifies her from being the NDC member of Parliament. The Supreme Court overruled the High Court and said that Dr. Rawlings, so long as she was going to be, by the time of the election, a registered voter, she was going to get the opportunity to cure that. They should allow her to participate in the party's processes. That until she files at the Electoral Commission, those qualifications listed in the Constitution do not come for the test. The test of those qualifications listed in the Constitution for a member of Parliament happens and occurs at the time the person files at the Electoral Commission. Justice Eni-Eboa dissented and took the view that if Dr. Rawlings wanted, or any other member of Parliament, wanted to be a member of Parliament, that person should be qualified by the time the person conceptualizes the idea at the party level to become the party's candidate. Let's look at this video. This is Justice Eni-Eboa appearing before Parliament's Appointment Committee, and I'm demonstrating that he's a man of very firm principle. And his dissenting opinion was put to him, that you dissented in this matter. It was 4-1. He was the one. The opinion was put to him that you dissented in this matter. Why did you dissent? Here, Justice Eni-Eboa.
Adom-Otchere and the National Democratic Congress. Alors, what is your judicial philosophy that influenced your decision in your dissent in that ruling? What judicial philosophy informed your dissent in that ruling? Mr. Chairman, yes, that case came before us when the honorable member of this house, Dr. Zanetta Rawlings, mounted an application to the Supreme Court for us to quash the ruling of the Accra High Court, because the Accra High Court had embarked on interpretation of, I think, Article 94, which says, among other things, that if you want to go to Parliament, you must be a registered voter. On their pleadings, I think there was an admission that the honorable member of this house had not registered them. And the judge thought that, okay, this one doesn't raise any issue of interpretation. It says clearly that before you enter Parliament, you must be a registered voter. And the lady, out of candor, the honorable member, admitted that he wasn't a registered voter. So it's like, if you take the presidency, you must be 40 years. So you are telling me that, oh, a party will certainly elect somebody who is 39 years, so that at the time of the polls, he will be 40. And I strongly dissented, because you must be qualified before. Because that is a step forward. You go for primaries to do what? You go for primaries to contest parliamentary elections. So at that time, the Constitution has declared the honorable member as unfit to be a parliamentarian. And what was the exercise as qualified for? It was for parliamentary elections. And well,
what was your philosophy?
In Ghana, we don't have to be with due respect asking judges for philosophies when it comes to interpretation, because the Constitution is supreme.
So you obey the Constitution.
Yes, that is it. That is the basic law. Yes. So that was.
So you heard His Lordship Justice Eni Yeboah. There he is. Justice Eni Yeboah is over there, and that's the point I was making about him. That is the level of his principle. So he is the president of the court. He's the Lord Chief Justice. He's presiding over the election petition. There are 7 of them. We're going to go through all of them and tell you what we know about them. Maybe it can help you formulate something. We don't know, but that's our purpose for tonight. Okay. Next is His Lordship Mr. Justice Philip Yao Apau. Okay, Mr. Justice Philip Yao Apau is also a High Court judge. I forgot to mention that Justice Eni Yeboah is 68 years old. His Lordship Justice Eni Yeboah is 68 years old, and 2 years' time he'll be retiring from the court. He is the president of the court. So, Mr. Justice Yao Apau, here on the screen, is also 69 years old, and he will be retiring from the court next year, or I think this year, Mr. Justice Apau. Who is Mr. Justice Apau? Now, he's one of the also very forthright judges. He was appointed to the court by President John Dramani Mahama, the petitioner in the instance case. And when I spoke to the lawyers today, they told me that if you want to describe Justice Apau, you have to look at him like a devout Presbyterian of sorts. You know how Presbyterians from Okropon, how they are. They say that's how Mr. Justice Apau is. Very, very firm, very, very principled, but also very nice. And very nice to counsel, I hear. Mr. Justice Apau is one of the Supreme Court judges that they say is very, very nice to counsel. They describe him as very respectful to counsel. That is to say respectful to the lawyers. Some judges can be brutal sometimes to the lawyers. But Mr. Justice Apau is one of those that is said to be conservative. He's very respectful of counsel. And he's your Presbyterian sort of pastor, your Presbyterian guy. Yao Apau is the second judge on this matter. He's 69 years old, appointed by John Dramani Mahama, the petitioner in the instance case. And so he's part of the 7. Okay, let's move on. This is Lordship Justice Samuel Mafosao. Justice Samuel Mafosao is 63 years old, yeah? And he's been on the Supreme Court not too long. But he's one of those that they say is a very exciting man. He's quite exciting. He's also thought to be conservative. It is reported that he supports the status quo. He likes the laws to remain as they are. He likes the Constitution, the sanctity of the Constitution to be maintained. That's Justice Mafosao. There are some judges who are radical. They don't mind changing the law. They like changing the law. Mr. Justice Mafosao is said to be the opposite. He likes the law to stand, the Constitution to stand, the fundamental law of the land to stand. He has fidelity to the law. He's conservative in that regard. I don't know whether you get my point. These are Supreme Court judges I'm describing, and they are sitting on an important case. So I'm giving you a broad view of who they are and what they like and how they have been doing their law. The next one is another man that is interesting, Nene Adom-Otchere. Nene Adom-Otchere was the president, 2-time president of the Ghana Bar Association. Nene Adom-Otchere is a guy that has his views, very, very clear views. And Nene Adom-Otchere is one of those who does not hesitate to express his views. Nene Adom-Otchere is one of those people who does not hesitate to express his views. Now, he is also somewhat conservative, but a little bit of Nene Adom-Otchere takes you to want the right things to be done. Where something has been done. So Nana Megache is the kind of judge that where something has been done for a long time that is wrong, Nana Megache does not hesitate to say that this has been done wrong for 25 years. We should change it. That's the kind of person he is. And when he was president of the bar, he brought a lot of changes to the bar. He did many different things that doesn't happen at the bar often. And at the bar conferences, he spoke. And he was also very particular about the way the bench, the judges, about the way they do their work. Throughout his period as a president of the bar, Nana Megache was continuously talking about how the bench should organize itself and how they should do their work. So, having been nominated onto the Supreme Court, many people were excited that Mr. Megache will now have the opportunity to express, to live, and to manifest a lot of the things that he had been saying as a barrister. He's one of those very principled guys. I'm going to show you a video about him as well. Now, this video that I'm going to show you about Megache has to do with something that was happening in Ghana all the time, that he believed, other lawyers believe was wrong, and had to be changed. It was about this issue of president, vice president, and the speaker. So it was about the president travels, the vice president acts as president, and when the vice president and the president are both not in town, the speaker is sworn into office. A situation emerged where another lawyer, one of those thinkers that are likely to, that think along the lines of Nana Megache, and we call him the Venerable, may his soul rest in peace, the Venerable Right Honorable Peter Alajete, the former Speaker of Parliament. He's also one of those kinds of lawyers and judges. And Ajete was of the view that having taken the oath of president once, when the president and the vice president were away, he need not take it another time. Nana Megache was speaking as president of the bar, and he made the point that these things must be corrected. So I'm showing you this video to illustrate the point that Nana Megache is one of those who has such fidelity to a certain kind of behavior around the law that he would like that behavior maintained. And he would like that behavior instituted, even if it has been violated for a long time. Here's Megache.
In my view, it's not required every now and then to take an oath whenever the president is out of the country, because he's taking the oath. So the speaker was right in not taking the oath. Now let's look at the events that happened. On Monday, President travels out of the country for some few hours, and Parliament is supposed to be recalled. Ministers who are supposed to be working either out of the country or supposed to be functioning in the various regions have to be recalled, so that the speaker is supposed to take an oath. And then Tuesday or Wednesday, the president travels to another place again. The vice president is absent. Are we saying that the intention of the framers of the Constitution is that wherever our parliamentarians are, the ministers are, we should get all of them, fly, come back, and then come and see, so that the speaker will be taking multiple oaths? I do not think that that is the intention of the framers. So
So that was Nana Megache. You saw that, and Nana Megache is 68 years old. I already mentioned that Mafusa is 63 years old. Nana Megache is 68 years old. 2 years from now, he goes out of the court, and then Nana Megache was nominated onto the court by Nana Addo Dankwa Akufo-Addo. Okay. Now this is one of my favorite lecturers. And, as I said before, the English word concomitant actually belongs to Professor Kote. Professor Niashi Kote for many years was teaching at the Faculty of Law. He's an expert in land law, and he became a very distinguished dean of the Faculty of Law. Professor Kote has taught many, including many who are judges today. Many people have passed through his hands. He spent a lot of time teaching at the Faculty of Law. He began his teaching career very early. Professor Kote was one of those who gained a PhD at a very early age. Professor Niashi Kote is his full name, and he is 67 years old. You'd expect Professor Kote to read a document before the court 10 times. That's the kind of judge you're looking at, and he's one of those sitting on this election petition. Professor Kote is the guy that you expect to read a document 10 times. You see, he's a land lawyer, and you know, land in Ghana has to must have attention to detail when you are doing land law. So that kind of attention to detail is with him. As a teacher, he takes his time to get every student in the class to sort of understand what he's saying. Professor Kote is the kind of person who will repeat a line in the class just so that it can sink into everybody's spirit. You know, he believes that the letter and the spirit of the law, all of it must be with students. The letter of the law being what you read, the spirit of the law sinking into your blood, as he says, so that when they wake you up at 2 a.m. and they ask you that what is in Article 64, you should be able to say it. That's the kind of person Professor Kote is. He really loves the law. And as I said, he's the kind of person who can read documents. He can read the same thing 10 times, and he has such attention to detail. So this morning, when documents were being filed to amend some of the errors that were made, and I saw that Professor Kote was on the court, I was just smiling that they better do these things very quickly, because when the matter starts and the document gets before the judges, Professor Kote is one of those who read a document and tell you that this your paragraph is wrong, this one is wrong, that one is wrong. Now he's on the bench as well. He's sitting on this case. Professor Ni Asikote, also nominated by Nana Addo Dankwa Akufo-Addo onto the Supreme Court. Professor Asikote is 67 years old. Hey, there comes the woman, and this is her lordship, or her ladyship, as they say these days, Mariama Owusu. Now, Mariama Owusu, her ladyship, Mariama Owusu. If you want to call somebody a master of the Court of Appeal, that's the judge. This is the judge that you call a master of the appeal, as they say. She spent a lot of time at the Court of Appeal. She's been at the Court of Appeal for a very long time. What do they do at the Court of Appeal? At the Court of Appeal, they listen to cases that have already been decided by the High Court. So the Court of Appeal are these, as they say, the three wise men who sit as a panel of three all the time, and they look at cases that have come from the High Court. So by being at the Court of Appeal for such a long time, Mariama Owusu has developed a certain second eye to every legal issue. That's what happens at the Court of Appeal. When you sit at the Court of Appeal for long, you develop a second eye. I mean, lawyers, all the people will pick a matter and then look at it straightforward and deal with it. Court of Appeal people have the patience to always look at the other matter, something behind, something you haven't seen. They're always looking for a second eye, because what they receive at the Court of Appeal is final conclusive judgments of the High Court. Rulings of the High Court, final conclusive, and they are expected to rule on those matters as well. They are expected to put on trial the judgment of the trial judge. That's what they do at the Court of Appeal. So when she's putting on trial the judgment of the trial judge, for you to be successful at the Court of Appeal as she was, you have to have a second, third eye to look at these things. It is a blessing that she's been added to this panel at the Supreme Court, because she's going to provide the court of 7 judges with that kind of resource. The resource where she's able to see something that other people may not see. She's always looking at the second eye. What is on trial now, as far as the election petition is concerned, is the declaration of the first respondents, the Electoral Commission. It's the declaration of the Electoral Commission that's on trial now. So that declaration is going to be scrutinized. And the petitioner, President John Dramani Mahama, spent a lot of time, as they say, 30 of the 35 paragraphs about the declaration. So that's what is on trial. Mariama Owusu is going to be able to provide that resource that gets you to see what is behind. So that's Mariama Owusu. She's 67 years old, appointed to the court by Nana Addo Dankwa Akufo-Addo. Okay, so this is also Gertrude Tokonu, Her Lordship Gertrude Tokonu. She is the youngest of the 7. She is 58 years old. Gertrude Tokonu is 58 years old, and she had extensive corporate practice. She also has a master's in an area that many people don't have as far as lawyers are concerned. She has a master's in construction law. So Gertrude Tokonu and Professor Kote will be able to have a lot to talk about when they are not sitting on the bench. Land law and construction law. She's a master and expert in construction law. Gertrude Tokonu had extensive corporate practice, and it's interesting, you know, how these things turn. I'm going to give you some filler that is very interesting. In her days as a corporate lawyer, Gertrude Tokonu used to work at a law firm called Willie Fugger, a law firm in Accra, famous law firm, big on corporate, Willie Fugger. And guess who was working in that law firm with her as a colleague? One of the barristers who will be appearing before her in this election petition was one of those who used to work with her in that law firm when they were both being built up as corporate lawyers. I'll show you that in a minute. For now, let me conclude on the 7. I'll come to the lawyers and then I'll tell you who that person is. But for now, I'm done. These are the 7 people who are going to be sitting on the Supreme Court. Who are they? Gertrude Tokonu, Mariam Owusu, Professor Niashi Kote, Nene Amegache, His Lordship Mafusao, His Lordship Justice Yao Pao, and the main man, the learned Chief Justice, Mr. Justice Eni Yeboah.